So technology is getting itself together. Finally, I think we'll be able to start another amazing night. Oh, I did something. I don't know what I did. With the YouTube. Okay, play. So, good evening. Welcome to Medical Mondays with Dr. O. Welcome to another amazing evening. And tonight, we will be continuing on the financial health. I am Dr. Toyin Okwesami, a medical doctor, family practitioner, HIV specialist, and I treat substance use disorder in Maryland. As you know, we've been discussing financial health on Medical Mondays with Dr. O. And we started this financial health a few weeks ago because of the mental health issues that are associated, in recent times with financial issues. We have learned on this forum that there's so much we don't know and that we needed to know, thank God, that we now know, we are aware of, that could make our lives better, easier, and also help us to generate generational wealth, which we need for stability, for good health, especially good mental health. Tonight, we're continuing in that arena, even though we will switch gears next week. We'll continue tonight with our own attorney, Jumoke Oladapo, who is the CEO and managing attorney at Ivy Law Office in Greenbelt, Maryland. Our law practice focuses on U.S. immigration law, estate planning, and trust, which she'll be talking to us about tonight. So she helps individuals to live and work with legal status here in the U.S., and of course, to navigate, estate planning, as we will talk about tonight. For estate planning, she focuses on helping families accomplish a healthy transition of their family wealth by providing legal guidance regarding their family, business, and assets. The outcome of the planning helps to protect the families and assets from conflicts as well as litigation. So, Attorney Oladapo holds a Master's of Law degree from the University of Baltimore, Maryland. And I'm going to now revert to her to share with us what we need to know tonight. And I apologize for the technological challenges we had before starting. So, Attorney Oladapo, the floor is yours.
All right, thank you very much, everyone. I don't know if you can see me, but thank you so much, Dr. O, for inviting me to be a part of this great course. And good evening, everyone, for joining in today. I look forward to this being a very worthwhile time together this evening. I really apologize about the Zoom issue, and hopefully we won't have that until we are done this evening. Okay, so the best way you can help me along with the screen, with the presentation, please, because I wouldn't be able to maneuver around it while using my phone, okay? So the next slide, the best way to learn this night is to put your phone on silent. Close your door. You deserve this time for yourself and ultimately for your loved ones. The next slide. So I have a gift for those who stay till the end, and you'll learn more about it towards the end, but it's going to be a one-to-one complimentary meeting to be able to speak more about your family, your assets, if you'd like to learn more about estate planning. And Valentine's is in the air, so we have a Valentine's Day bonus, which is going to be up to a credit of $750 for those who want to do a planning session. So stay tuned to the end to learn how you can gain this. Dr. Ho gave a good bio, so I wouldn't stress more, but we've been privileged to serve a community for, I've been licensed for like 13 years serving in Maryland, and we've served thousands of individuals. And as a result of that, got a lot of thank yous, I'll call, or accolades, some of which you're seeing on the screen, but I'm not going to say a lot about that. But you are going to be in good hands. So, but my goal for estate planning clients is that we help in our office to keep families and loved ones out of court and out of conflict in the event of incapacity or death through proper estate planning. So estate plan may be a big word, to a lot of people. So let's go back to what is estate plan, all right? So estate plan may be a big word to some people. Some people think we're talking about real estate when we say estate planning, but I want to break it simple. So the page before this one, it simply means making a plan in advance and naming who you want to receive the things you own after you pass away or in the event of incapacity. A good estate planning is so much more than that. But this is the simple beginning. You make advanced planning about who you want to receive what in the event of incapacity or death. An estate plan is so much more, and everybody has a plan. Everybody has an estate, okay? So a lot of people say, I don't have anything or have something small, but if you have an estate, then you should think about a plan, okay? So what consists of an estate? An estate is everything you own. So if you own a car, I can't see you, but if you can raise up your hands or type yes in the chat. If you own a home, type yes in the chat. If you have a real estate, type yes in the chat. A checking or a savings account, does somebody have that? Please say yes in the chat. Do you have furniture in your home? Yes. No matter how small or big what you have is, if you have a modest amount of assets from any of the things I've mentioned, yes, big yes, you have an estate. And you should be thinking of putting a plan in place, because when you can no longer control what you have, you need someone to control it for you. All right? And the people you want should be the people you choose. And we'll learn more about that. Next slide. Some myths about estate planning. All right? So some people don't want to put plans in place for themselves, particularly in the culture, African culture, when you say, oh, go put a will in place. They say, I shall not die, or go put a plan in place. They said, I'm still young. But these are some things that are barriers or limiting beliefs on why people don't want to put a plan in place. They think it's for the old folks or the seniors, or they think they still have plenty of time. They're still young. Or maybe they think you don't have enough. You think you don't have enough. From the slide before, we found out that you have enough. Am I right? Or you think you are not wealthy, or you think you're too busy. Everybody right now is very, very busy, and they keep on procrastinating about putting a plan in place. Honestly, if you fall into one of those categories, you need to work on it and change so that you do the right thing for your loved ones. So the next slide. Who do you want to protect? Who needs your protection, or what needs your protection? If you have any of the things in this picture or much more, you need to protect them. If you have money, if you have children, if you have a home, if you have a life insurance or retirement plan, you need to know that you need to protect these things. Or even if you have children, you need to protect them. So let's think about it. Pause a little second, think about it. Who needs your protection? What needs your protection? Please jot down something for me, because those are your whys to why you need to get your estate plan done. Are we done on that? So having an estate plan in place will give you a total assurance and comfort of knowing that your family will be well taken care of in the event of incapacity or death. Next slide, please. All right. So the slide after that, next. If you have some assets, you want to have the peace of mind of knowing that your asset is not going to be lost to the government, or you're not going to be paying excessive taxes on the assets and the monies you have. That's why you need to have an estate plan in place. Do you agree with me? Maybe yes, put it in the chat. Another thing is that a lot of money is lost to the Department of Unclaimed Properties. Next slide. So in Maryland, for example, over $700 million worth of assets is in the Department of Unclaimed Properties every year. Why? Because somebody has an account somewhere that their family don't know about. Somebody has some stocks and bonds that only them know about. Somebody have something that their family doesn't know. Assets gets lost. So there's somewhere called Department of Unclaimed Property. So if your account has been open and dormant for a couple of years, your assets is going to go there and your assets will be lost to the government. Why? Because you don't have a plan in place for your families to know what you have and where to find them. So when you do estate plan, you want to be more financially organized. Someone type, I want to be more financially organized. Also, you will save on a lot of taxes, a lot of probate taxes, if you have estate plans done the right way, okay? Another thing that we want to talk about is self-care. I know because we're on Medical Monday, we are learning about self-care as well, in addition to financial and estate planning care. So if you want to make sure that your choices are honored and you're choosing people that are turning your wishes into directives in the event of incapacity, then you want to have plans in place. So things like having a power of attorney in place and things like having a healthcare directive in place is very, very important when you're doing estate plans. All right, so this takes care of incapacity. Please, the question I want to ask you again that I require a yes or no is this. Do you have a plan? Do you have an existing plan or you don't have a plan? If you have a plan in place, type yes. If you don't have any plan in place, type no. 1 minute or 30 seconds. Please, in your chat, type yes, no, yes, no.
I'll tell you, the Medical Mondays family probably would respond, with questions later. You'll get more bang for your money that way. But they're responding.
Okay.
They may not get an overwhelming response.
Yeah,
but they will ask questions.
Okay.
Afterwards, yeah.
All right. So if you don't have any plans, if you have a plan, the question you want to ask yourself is, when was the last time you reviewed your plan? A lot of people have plans and keep them in the shelf for years and years and years. And do you know what happens? The plan will not work when they need it or when their family needs it, because the law may have changed, their assets might have changed, even The beneficiaries may have changed by the time it's needed. So when you have a plan, you want to review your plans regularly, at least every 3 years. And if you don't have a plan, if you answered no, if you don't have a plan in place, the state has a plan for you. Next slide. And if you want to know what the state's plan is for you, it's called probate. In the event of someone passing away, and in the event of incapacity, it's called guardianship or conservatorship. Okay, so probate. When you don't have any plan, like a will or a trust, if you pass away, your assets and your family will have to go through the probate court. Okay, if you have just a will, also it's a direct access. You're giving yourself and your family to the probate court. And when you get to probate, it's a lot that goes on. First of all, you see the pipe you're seeing over there? There are a lot of people that are waiting to get their piece of the pie. The attorney's fees, the executor's fees, the creditor's fees, the court fees, the bond fees, a whole lot of fees will be paid to outsiders and third parties before your family gets the share of your assets. Next slide. So in Maryland, I'm situated in Maryland. I know a lot of us are all over the nations, but this is it. This is popular and similar among all states. First of all, if you don't have a plan or you just have a will, a probate process is public. That means your will be published online. Your estate's notice will put in the newspapers. Everybody will know that you're doing something. So someone passed away and they're having an estate open for them. Also, the time to process probate is like 24 months in Maryland, okay? That means the judge will need to sign off on all your stuff before your beneficiaries or loved ones will be able to have your assets. The same may be similar in other states too, okay? So if you want your families to have access to your earned money early enough, you want to plan better than going through the probate system because you don't have a plan or you have a faulty plan. Also, the cost of probate is very high. But if you want to avoid probate altogether, okay, you have to do something better than not having a plan in place or just having a will, okay? You have to have what we call a fully funded revocable living trust. When you have a fully funded revocable living trust, it takes out your assets from your personal name and it goes to the name of your living trust. And if you pass away or in the event of incapacity, your house will no longer be in your name. It's going to be in the name of your trust and it's going to avoid the probate court. Also, you look at every other assets that you have, like who are your beneficiaries on your insurance policy? Who are the people that your stocks and bonds are going to? You do a full planning with an estate planning attorney to make sure that things are in place to avoid probate, to save your family money, to preserve your family wealth, and also that your stocks, your assets are going to your beneficiaries in as quick a time as possible, with a little money as possible going to outsiders and everybody happy. At the end of the day, why you need to have a plan is because you need to have the peace of mind of knowing that you're doing the right things for your family without the court's involvement, without a judge making a decision about who is getting what or who is going to be helping you in the event of incapacity. So I know that I'm almost out of time or out of time. The next slide. If you plan well, this is the experience you'll have. You'll be making informed and empowered decisions by yourself, for yourself and for your loved ones. You'll be saving thousands of dollars upfront and back end. Also, your assets will not be lost upon death. Also, you'll protect your family assets from outsiders, and you will know that you are making the right decisions that will keep your family out of court and out of conflict. Ultimately, if you have a plan in place, it will work for you when it's needed, and it will work for your family when it's needed. Let me stop there. A good way to start is to have a family wealth planning session. That's like a consultation, okay? And you can get that scheduled with me. The next slide, which is a Valentine's Day slide, is my gift to you. If you schedule a family wealth planning session, this Valentine's Day is the best way to show love to your family so that you'll get all your financial ducks in a row. You can make sure that your kids are taken care of by the people you know, and trust and love will be passed to them if something unthinkable happens to you. The Valentine's Day gift is a $750 meeting value, and you can get it for free if you schedule a family wealth planning session after this meeting by calling our phone number, next slide, and using the code Medical Mondays. Next slide. Jot down the phone number, call tomorrow, and use and say Medical Mondays to get a free family wealth planning session in place. Anyway, that's it from me. I hope it was very okay, and we can ask questions from now.
Thank you so very much. Very okay? No, it was fantastic. Because this is information we need. A lot of us don't know this. We don't have plans in place, and we just live in. Last year, 2022, around me, friends and family, I lost 15 people, and none of them had life insurance to even start thinking of trust. So, or estate planning. This is very important. And so the floor is open to questions. Dr. Jagbe, your question, please. Dr. Jagbe. Are you there, sir?
Yes. Thank you so much for the presentation. I think this is one area of planning as adults that seems to be suffering the most for all the reasons that you gave when you started the presentation. My question is, could you talk more a little bit, if you have time, on trust, the different kinds of trusts? And if those are possible, what are the advantages of those over just having a will?
Thank you very much, Doctor. So a trust, and in this case, is a sophisticated way of planning, okay? And in simple terms, a trust is an agreement that you have between you as the owner or creator and you as the manager of the trust or the trustee, and you as the beneficiary. So while you're alive, you give your assets to you as the manager or the trustee. You still use your stuff, but it's no longer in your name, okay? And when you pass away, the trust could be revocable while you're alive, and will become irrevocable after you pass away. And why does this happen? Anything in your personal name upon passing away, upon death, will take you to the probate court, will take your family to probate. But when you take things out of your name, there's nothing to go through the probate court. That's a simple explanation of what a trust is. So basically, it's an agreement. And there are different types of trust. And for this purpose, I'll keep it short and simple. The revocable trust, and the irrevocable trusts, okay? The revocable trust means you can revoke it. You can make changes to it. The irrevocable trust means once you give your asset to that trust, you cannot make any change to it. So if I give you an option that, oh, I can help you protect your asset, but you're no longer going to be able to have access to it at all, that's irrevocable. And if I give you the option that, oh, I can protect your assets, but you'll be able to assess it and control it, that's revocable. But at the end of the day, if you have a revocable trust, when you pass away, it avoids probate if your assets are all funded into your trust. The irrevocable trust also does the same thing, but while you're alive, you don't have control over it.
Thank you.
Okay.
Thank you so much.
You're welcome.
Auntie Tower, you have your hand raised, man. You can unmute.
Good evening, everyone.
Good evening, ma'am.
Thank you, the speaker. Sorry, I can't remember your name. I'm so sorry about that.
Jumoke Oladapo.
Yeah. My question, you were talking about the revocable and irrevocable trust, and when you first started your speech, you were talking about generational wealth. So if you put your assets in a trust and you want it to be generational, you don't want just your immediate children to gobble it, you want it to be passed on and on. So which of the trusts do you do?
You can do a revocable trust, and there are a lot of instruments or vehicles in the trust that can make it a generational gift for your children.
Okay, so if you do revocable or irrevocable trust, and there's a clause there that can make it be able to be passed on to the other generations. If you have a property that you have maybe one or two of your children as part of the property, listed as part of the property, so what will happen if you passed away? Because I think they call it gerrymandering or whatever. I can't remember the name they gave it. But they said automatically it will pass on to that child that you put on the deed with you. How does that one work?
All right. So some people plan. I'll say it's a level of planning. Okay. But it's not necessarily the best form of planning. Okay. So if you have more than one person's name on your deed, it could be your spouse, it could be your children. Do you understand? If one person passes away, then if it's a joint asset, joint tenancy, then it automatically belongs to the surviving spouse or the surviving children. Okay. If you hold those properties as tenants in common, then they have their shares. It doesn't necessarily go to them automatically, like 100%. They continue to have their shares, and your part goes to the probate court. So when you put in the names of your children on assets, then how is it being titled? You need to know. You need to be very, very aware about that. Okay? Yes. So the best way to title it will be joint tenancy with right of survivorship. Then they get it automatically. But it has some it could have some tax implications at some point. So it's a level of planning, but better levels of planning will be if you want to own your assets while you're alive and pass it to your children after you're gone, then put it in a plan, a set plan.
Okay, with savings or CDs or all that kind of instruments, you know, they always ask you, who are the beneficiaries? So if you put down the name of the beneficiaries, if you pass away, I think automatically it goes to them without going to probate.
Exactly. You're right, ma'am. So what you're talking about, there are some assets that are going to be non-probate assets. Okay. There are some assets that are probate assets. Going back to my simple explanation, anything you have only in your name goes through probate. There are non-probate assets, which could be joint assets, and there are non-probate assets, which could be anything payable to beneficiaries. Okay. So if your life insurance, for example, is made payable to beneficiary, if you name a beneficiary on it, it goes to that beneficiary. If you name a beneficiary in your bank account, it goes to that beneficiary. So it wouldn't go through probate, correct? However, what you want to ask yourself is this the best form of planning? What if that beneficiary passes away, either before you or about the same time? Okay, then you need to be able to plan better. It's a level, like, let me put it, level 1 planning, good. There are better ways of planning in such a way that even if you have an account, bank account payable to beneficiary, after that, what happens? If something happens to that beneficiary, it goes to probate. And also that there are a lot of tax consequences that may go with such. All right.
So if you have it, if you name like 2 beneficiaries, God forbid, and one of them passed, and you said 50%, will they automatically give the 100% to the other one that is still alive, or they will take half of it to probate?
So you have primary beneficiaries and you have contingent. Yeah. So 50-50 is different from primary and contingent. Okay. All right. So if you have 2 beneficiaries and they're primary beneficiaries and you don't name a contingent beneficiary, then that's 50 for the person that passes away will go through probate. But if you name a contingent beneficiary who is an adult, all your beneficiaries should be adults, not children. Then the contingent will have that asset. Okay.
But if it's if you do it as a class, as children, as opposed to naming them independently from one another, how about that? If all children, if you kind of identify the beneficiaries as my children, and you have 3 children.
Under what type of gift?
Usually like life insurance.
I have not seen where you just say to my children, okay? Because children have a lot of beneficiaries. Usually the insurance policy will tell you to name the beneficiary. Okay. So because your children can be your biological children, adopted children, deceased children, stepchildren. So you don't want to leave gaps for interpretation.
Okay.
Thank you, ma'am.
So I have some hand raised and I have a question in the chat box. I'm going to call on Dr. Maureen Booker. Kindly unmute.
Yeah, I did.
You
Okay.
did. Fantastic.
Thank you for that wonderful presentation, Dr. Oladapo. My question was on joint tenants. We have joint tenants. Now, as an anesthesiologist, if I am sued, does that lawsuit go against my husband, or how should I say? I heard that in joint tenants, they have to sue both of you to get the benefit. Is that true, or can they just sue me alone? and get the benefit, and my husband would lose something.
Both of you.
Those two both of you, man.
No, for my job, if I am sued
Yeah,
without him,
exactly.
let's say a
So,
patient sues me.
let's say, for example,
Mm,
your home, you have a mortgage on your home, okay? And the deed is in your name and the name of your husband. Am I right? For whatever reason, you default on the mortgage and they take it to foreclosure. They're going to sue both you and your husband.
mhm.
Okay.
No, it's not the mortgage.
Because
Mm.
saying it could be any other thing.
I'm talking about patients at work, something that's totally different. Or if he dies and he owes somebody and they sue us, could that go against my home? Mhm.
They're suing you.
If
They
they're
can take
suing me and not him. Mhm.
lien. So they're looking for where the deep pocket is. Okay.
Mhm.
And they're trying to put a lien
Mhm.
on what you have. So
Mhm.
if you have belongs to yourself and your husband,
Mhm.
they'll put on it. It's going to be both you and your husband that they will name because that's what they want. They want their home. Am I right? Okay.
Yeah. Okay.
But they may not be able to get more than your 50%.
Mhm.
Do you understand? But it's
Mhm.
going to cause a lot of issues up front because his name and yours are on the asset.
Mhm. Okay. So the best thing is probably put it in a trust. They can't go against that. If the home is in a
So for
trust or everything. Mhm.
yeah, so if you're looking at asset protection, okay, if you know that there's anticipation of lawsuits and all that, and you're looking at
Mhm.
asset protection as your main goal, then you're looking at stronger vehicles beyond a revocable trust. You're looking at like irrevocable trust, where it goes out of both of your name entirely. But if you
Mhm.
don't have creditors suit in anticipation, then you can just go irrevocable trust. Yeah.
Okay. Thank you. Mhm.
So just to be clear, when you put your assets in the trust, Dr. Buka's question is very important, then you're protected from lawsuits, correct?
It depends.
Or it has
That-
to be irrevocable trusts to be protected.
Yeah, if you're looking at creditors protection for you, okay, then maybe you want to look at irrevocable trust. But by the time you put all your assets into irrevocable trust, then what do you have?
Nothing.
Not. Okay. So you don't want to put all your assets into irrevocable trust. Maybe some, maybe a few. Do you understand? So that you have something just in, but not enough for creditors to get all that you have.
So what does the trust protect then? I'll ask that later. Let me go to the next person.
So revocable trust protects you from probate or protect your family and your assets from probate in the event of incapacity or death.
Mhm.
And when you avoid probate, you're preserving some of your family's wealth because you will not have to pay a lot of probate taxes, inheritance taxes, estate taxes, and all those taxes that people are taxed on their assets at the point of death. Okay? So if you want to avoid probate court, then you're looking at a revocable trust. If you're looking at asset protection for you, then you may be looking at some asset protection irrevocable trust. There are a lot of other trusts. If you have special needs children, there's special needs trust for them. You understand? We have some irrevocable trusts. So those irrevocable trusts are for assets protection. Okay.
Thank you. Thank you.
Doctor,
Dr. Izugu,
oh, okay. I
kindly
was just
unmute.
gonna add something.
Dr. Izugu,
Okay.
was before yours.
Sorry.
Thank you.
Thank you so much, Dr. Oladapo, for the presentation. It's really wonderful. I have a couple of questions. So from what you're saying, actually, it's good to have both revocable and irrevocable trust, depending on what your need is. And two, if those non-probate assets, is there a reasonable reason to put them on a revocable trust or just to leave them out? I just want to get your legal opinion on that. And a revocable trust, is that pierceable from what you're saying then in terms of what you put into it and legally?
Can you say the last part of your question again?
A revocable trust, okay? Let's say you have a living revocable trust. Is that pierceable legally?
Okay. So, first of all, you said, is there any reason to put the non-probate assets in a trust?
Yes, is there a good reason to put that, like even a revocable or non-revocable trust?
So a lawyer will always say it depends, okay? So it depends on what assets and what your goal is. So for example, if you have a bank account and you name a beneficiary, payable on death beneficiary, I've already given that example before. That what if the beneficiary passed? Okay. So if you take a life insurance and you name a beneficiary to your life insurance, if your life insurance beneficiary is a minor child, the minor child is not going to be able to have that gift until they become an adult at 18. So if you named a minor child or a grandchild as a beneficiary of your life insurance because you want to provide for them, and you pass away, that life insurance benefit, death benefit, will not go to that grandchild until 18. And now when they become 18, guess what? They have $1 million at 18. Is that what your intent is? What is the child going to do with that $1 million? Do you understand? So when you're working with an attorney, they're thinking deep and wide about your need and how to best protect you and plan to meet your need in such a way that is not going to expose you or your beneficiaries to unnecessary liability. So that's why I said it depends. Normally, general rule, there is no need to put those things in a trust. On a secondary level, so if you have like a responsible adult that you're giving $250,000 to, maybe that's cool. If you have a responsible adult that you're giving $5 million to in life insurance, maybe that's not cool. So you need better ways of planning around those. Okay.
Makes sense.
Thank you.
Thank you. And on the second one, the pierceable of the revocable life insurance, just to.
So piercing, the answer, so there are different layers of planning, okay? The first one is for you. The second one is for your series, all right? So there are vehicles for you. If it's in a revocable trust, it's pierceable because you are the beneficiary. Am I right?
Yes, in a way, yes, because you can still decide.
So for an aggressive creditor can pierce it. But if it's your children, it's in a trust for your children. Do you understand? This second level, you already passed away, and now it's in a children's trust. It's not theirs because it's in a trust for them. if you have that vehicle that says you're not giving it to your child outrightly, you're giving it to them in a trust, intergenerational, generational protection.
Yes.
And so a creditor will not be able to pierce that child's gift because it's not in their name. And maybe they're not even the trustees.
Interesting.
Okay.
Yes, thank you.
Thank you. Attorney Tinu Akinshola, you can unmute, please. Thank you.
Thank you. Barrister Jumi, you did so well. Excellently, as always. Thank you for coming tonight. Yeah. So you are the expert on this issue. Yeah, I know. But there are little intricacies that people are asking, which I believe should be put out there, you know. And I wanted to, I put up my hands first time when I believe it was Antitawa, and then somebody asked some other question with business issues, you know, involved. So I know that, and of course you can add flesh to this, bearing the tax consequences. Everything that is named in another person's name, maybe your beneficiary, your children, or any other person, even when you pass away, assuming we are not even talking about probate and all that now, you know, for example, your life insurance or any other policy that we usually would indicate our children as beneficiaries for at work. All those will, of course, have tax consequences. And I try to put that in the chat. Now, going by the other question about Dr. Booker asked, I see her asking questions to me in two different ways. The one thing is the business aspect and then her personal self. And I say that because I want to know this business that she's saying that could be sued or she will be sued. Are you going to be sued in your personal capacity? Is your business an LLC, or you operate a sole proprietorship? Because all that too have these consequences we're talking about. And I thank God that Attorney Jumi, you answered that in terms of a lien that could be placed on the house, you know, that she owned jointly with her husband. So, but bearing that in mind, if she operates her medical practice as an LLC or a PLLC or an Inc., which is a corporation, they will not be able to come to you personally. You will only be liable to the extent of your business liability. I don't know if I say that correctly or rightly, but what I'm trying to say is that, yeah.
I get you. If you have your business as an Inc., okay, best from protection, because you are a separate entity from your business, completely separate entity. If you have your business as an LLC, particularly if it's a sole member LLC, they can still come after you to the extent of your, I'll call it shares of your membership. Okay. And if you're a sole, that means you have 100% membership. It's not the best. But if you're a sole proprietor, that means it's you. Then you have no protection at all. So how did you incorporate? Is a good question to ask yourself. Thank you, ma'am. You can continue.
Okay. Oh, I thought, yeah. So I'm glad you understand where I'm going. So she needs to tell us how her business is being operated, because that will make the difference, right? And then naming your children in the will. Let's say we are dealing with a will alone now. You are the expert here, Stajumi. But of course, knowing one or two things about wills and trust also, it's usually the best to specify, to indicate specifically the children's names and then the proportion with which you want each one of them to inherit. If you say all my children, they don't know how many children you have there in the world. So they will have to be testing everyone, paternity, and then if you don't indicate what proportion you want your children, maybe you have 5, maybe you just want them to have it as equally, you need to say it. But if you want 10%, 2%, 20%, it also has to be told. Now, saying all that, will on its own, this is what Sister Jumoke is trying to tell us. Will on its own, it's not just the best, but supporting it with trust, living trust, which will help us to be able to save a lot more, in terms of taxes. And that's the first 2 or 3 slides you shared. So the attorney's fees, all those things will make your estate to be depleted even before they are able to share to the children or your beneficiaries, because taxes too is there. But if it's like a trust, then not only that your will is operational, because when you die intestate, that means you died without a will. That is when probate will step in. But if we go in, I'm saying this because I've been saying I have to do it myself too. And of course, Sister Jumoke is going to be my attorney for that. So, yeah. So we need
And
to
you,
now.
and you can get the free consultation through Medical Mondays.
Oh no, I've already gotten mine. I went to her to know more.
Just accepted that you can get that free consultation.
Okay. Okay. I went to her to get more, So
Okay.
what I'm saying is that with all intents and purposes, this is the best, I would say the best route to consider. Yeah, we have our will. We'll be reviewing that will, because by the time, in 3 years, 4 years, things may have changed. That's why she says update and review, so that redemption would not attach to our inheritance or estates. And then taxes will not eat up all the other parts if we put it in the route of living trust. Thank you.
Okay, thank you so much. Attorney Oladapo, I have a question in the chat box that said something about that, but it's more specific. Before I call on Auntie Tawa to come back again, she has her hand raised. It said, my sister Marsha said, I always thought that you only need a will to ensure your assets go to your loved ones. But the living trust sounds like a better option. Can you expand a bit? And she says this session was great, by the way. And should you have both a trust and a will? So she wants to know, all most of us know about is the will. So can you expand a little bit further what the difference is and what your advice will be to somebody considering to take care of their estate?
Yeah, thank you very much. A lot of people think a will, all we know is a will. That's the most, everybody, do you have a will? Do you have a will? And everybody thinks a will answers all questions. And that's one of the myths that I mentioned in the early slides. But no, a will does not answer a whole lot of questions. In fact, if you just have a will, it's like suing yourself. Sheesh. So that your assets will go through the probate court if you pass away. So a will is a good place to start, because with a will, you will be able to mention the people that will help you administer your estate, and also maybe who you want to give what to. You're going to avoid conflict. Maybe, most likely avoid conflict if you have a well-drafted will, but you're not going to avoid court. But if you have a living trust in place, you will avoid both court and conflict. Okay, so if you have a trust, if you have a will, when you pass away, it goes through probate court. They do all this stuff, all the things I said under Maryland probate will happen and much more. The time, 12 to 24 months to process, the cost, all the pipelines I showed you, the publicity, as in I can go to the court out and look out Mr. X's will and see who he's giving what to, because it's on public record. But if you have a trust in place, it's a private document. Nobody knows what you have apart from the lawyer and the people you share it with. It takes less time. Okay. So if your trustee is ready to administer your trust in 3 months, it can be done because it will be done in the privacy of your lawyer's office with less cost, because you're going to avoid a whole lot of other fees and probate fees. I'll tell you an example of something that happened recently. There was someone that had a trust in place, but unfortunately, the person did not completely fund a trust. So she left 1 or 2 assets out of it. But our home was in the trust. Let's say the value of our assets, total assets, is $1 million. Our home, our personal property, our cars, and all that. Unfortunately, she passed away. But because she did not put a car into the trust, she had to go through probate. Let's assume the value of the car is $20,000 out of $1 million worth of asset. All that needed to be exposed was the $20,000 car. All other assets that were in trust did not have to go through probate. It was still a little hassle, but when she would be charged, she'll be charged the attorney's fee on the $20,000, and she'll be charged, the charge will be so much less than if all her assets was exposed through the probate court. You understand? So do you need a will? In the example I gave to you, if you have a trust, yes, you need a will, but the type of will you need is called a pour-over will. It's not a simple will. Okay? So the will say, I have a trust. Refer to my trust. So if we are giving anything to the court, we're giving the court that pour-over will that say, I have a trust. Do you understand? So I call it a backup will. You need that.
So, question before I start. When you said you can start with a will, what's the point in starting with it if it's not going to be, the end product? I mean, and I said that to say nobody knows when the time would come. So if somebody starts with a will and don't do the trust yet, and then they pass, it defeats all the purpose, is why I said that. So would you agree that it's better to have a trust and then have that backup will that will say you have a trust?
I think she dropped off. She
think
might
so.
be trying to log back in.
Yes, I think so. So, Auntie Tawa, a few minutes, please. But I really think from what our attorney had said, pour over will is what needs to happen. Yes, Sister Marsha, pour over will. We need to look into that more, because that just says I have a trust, and nobody needs to then delve into one's personal business after one is gone. Thank you, Sister Tinu. Pour over will. I need to remember that word. So I think personally that it's best to go for the trust and then do the pour over will and get one's estate situated, because we don't know the time and day. And, you know, one of the things we do quite often is take life for granted. We should stop doing that and just do the needful, my opinion.
Well, I think what she was saying, if you have a will first, at least you have in your mind who you want to give it to. Because sometimes going for the trust of may be so overwhelming. So if you decide you want
So
to
what I said, sorry about that. Sorry that the line went up. A call came in that's up bed. Sorry about that. What I was saying is this, in answer to Dr. O. There's some people that don't have enormous assets. Okay. So if you don't have a home, you don't have a child, if your asset is under $100,000, then maybe you just want to have a will. But if you have any assets over $1,000, you have children, you have blended families, you have a business, you don't want to have just a will, because your life is not a simple life. Do you understand? You want to look beyond that and have a trust.
Thank you. Thank you for that explanation. Well, I'm excited about it because you know what? We've learned how to generate that over 100,000 so that, you know, we've learned how to go into the $1 million range. And so trust is the way to go. And that is my prayer for every single Medical Mondays family, that, you know, will have enough to do the trust. Auntie Tower, you can unmute, ma'am.
My other questions is, when you were talking about state of Maryland. Does that law covers all other states, or is different from state to state?
Or even country? We have people from.
No, I'm going there. I'm going there. I
Countries.
just want to take it.
No, she can answer it together. You know,
okay.
Even other countries. She can.
So I spoke about Maryland because I'm licensed in Maryland. Okay. Each state have their laws, but all these are similar. The probate time may be a little different, but the publicity is the same. The costs may be different, but there's still a lot of costs. So the estate planning is state specific. Do you understand? That means each state has their own law that has to be adhered to. But the general idea is the same. The consequences is the same.
Then
and for the country, from country to country, wherever you are domiciled and your asset is domiciled is the country that will go the governing law. Okay. So for example, if you live in Nigeria, you have assets in Nigeria, it's the Nigerian law that will govern your estate plans. So you have to follow whatever that means, whatever the law is in Nigeria. Okay. So in Nigeria, for example, I'm not sure if they're versatile with having a trust in place.
They do.
But they know about having a will. Do you understand? Mm-hmm. So at least get a will done. Then tell your lawyer to call a lawyer in the United States to find out about having a trust done, because I know that we learned trust when we were in the university. So it's just for them to know how to get the law to get it done.
Then on this trust, do you have to file taxes for each of them, whether they are revocable or irrevocable? Do you have to file taxes for them annually?
No, if it's a revocable trust while you're alive, no. When you pass away, the revocable trust becomes irrevocable. And then you have to complete some tax forms and file taxes based on income. At that point, it becomes like an entity. and you'll have to file taxes on some things and also pay some taxes as needed.
You mean the
Then-
beneficiaries or the
Yeah,
debt?
the beneficiaries.
Okay.
Thank you.
Then on marriages, if one of the partners decided to give something to somebody while he was alive and now he dies, and the case went to the court. So what is going to happen? Because there's a case, there's a big person, the owner of Buccaneers game here did that to the wife, and the court took everything he gave to the children and gave it back to the wife. So, and tried to put it in trust, but they took everything from all those children and gave it back to the wife, because he gave the wife something, but it's just probably 10% of what he has or he had.
So did you have a trust in place?
Yes, he did. But when you are married, it's not that they are divorced. How could you do that?
Okay. So this is it. This is it. There is state law, okay, with respect to spouses and distribution, and some things need to be respected. When you are married, the ideal thing is to have a joint trust, okay, with your spouse, not a separate trust. If you have a joint trust with your spouse, in that trust, it's saying what will happen in the passing of the first spouse and what will happen in the passing of the second spouse. Do you understand?
Mhm.
So if you make provision for all that, what is happening to this person will not happen. So that means he did not have a joint trust in the first place, even though he was married. And maybe he decided to disinherit his spouse, and that's why the spouse fought in court and the court had to make a decision.
Thank you very
Oh.
much. Appreciate it. You did a good job. Thank you.
Thank you, ma'am. Are you in Maryland?
I'm in Florida.
She's in
Okay.
Tampa, Florida.
Could
So
you say
I have a
something about-
question. Go ahead, sir.
Sorry.
Go
Could you
ahead.
say
sir.
something about prenuptial agreements in relation to estate planning?
No.
No,
Did you say, did she say it or you asking?
I'm
sir?
asking, could she?
Oh. Okay.
Could you
Yeah,
throw
give me
some
1
light on
minute.
freedom?
Yes, I will, but give me a minute to get my charger. 1 minute, please. I'm back.
So did you hear his question?
It wants
Mr.
me to
Chair?
speak about having a prenuptial agreement.
It's asking if you can
in
have a
relation.
prenuptial agreement in relation to trust between a couple.
Yes. So if you want to have a prenuptial agreement, that is okay if you have a blended family, for example. You know, a lot of people with blended families want to have a prenuptial agreement. But now, what does your prenuptial agreement say? Because I see some prenuptial agreements like excluding the spouse entirely from their estate plans. Do you understand? So by the time you get that, you want to share that with your attorney so that they will know how to draft your estate plan. You don't want things to be conflicting. So yes, you can have a prenuptial agreement, but if your prenuptial agreement says your spouse is not getting anything you have, that is disinheriting your spouse up front. Do you understand? So you share that
Most
with
people
your
do
attorney.
that, and they say whatever they accumulate after they got married, then that can be shared.
Yes. Yes. But if they don't get anything after they got married, or
And
if
they
there's
got
a lot
zero.
of conflict up front, you know, there are a lot of complexities around it. I don't want us to belabor on that. But the essence is this: use an expert estate planning attorney when you have all these things, issues, or when your life is not a boilerplate life. Because you need to have an estate plan specific to you, not specific to Staples Farm, not specific to LegalZoom. You need to have an estate plan specific to you, your family, your assets, your family dynamics. So you have to use a lawyer that knows what they're doing, not a general practice lawyer. A lawyer specializes in estate planning.
Estate planning.
Thank you. So I have a question that is similar to that was asked by one of our sisters. She said, if you are married, but everything is in your spouse's name, spouse does not put you in the trust or will, what are the spouse's rights? Suppose the spouse decides not to do a joint venture. So what are that spouse's rights, whose name is not on anything, who the spouse did not put in the trust or will? What are the rights of that spouse? Do they have any?
If the spouse is the surviving spouse, the spouse may have to contest. You know, first of all, any assets you acquire in the course of your marriage is a marital asset. So the judge or the attorneys will have to look at it in that light. Okay. If you were not specifically disinherited, then there will be some determination by the court on what percentage comes to you. But you may have to contest the estate plan or the trust or the will if there is a need for it.
Great. So there's one more question. Can you say more about businesses? If you have an LLC, should it be changed to Inc., incorporation, or incorporated?
So if you have a business and the business is an LLC,
yes,
when you pass away, the business goes into your estates as part of your assets. If you, based on the number of the percentage of your membership. So if you're the sole member in an LLC, the LLC can go into your trust, the business goes into your estate. Okay. If it's an Inc., the Inc. is a separate entity from your person. The LLC is somewhat attached to your person. The Inc., you own shares. Okay. So your shares can be bought over by your family. Is your shares, the number of shares you have in that Inc., that will be an issue at your passing? The company may be able to continue running without you. So the best form of protection will be to have an Inc. All right. If you're forming a business, make it an incorporation for the purpose of liability, creditors, and all that. That's the best form of protection. However, having an LLC is a good place to be. What you don't want is to have a sole proprietor.
okay. So you can have an LLC, you're still protected, even though you are attached to it. If you're not a proprietor.
Yeah, so if you're sued, they can sue the percentage of your membership, you know, if you have an LLC. But they can't to you if you have an ink. You can see your person if you have an ink.
So what about nonprofit? Does that go with the same with nonprofit organizations? Should you do Inc. or LLC?
Profits are usually ink.
Inc.
Yeah.
Okay. Okay. Wow. This has been a wealth of information. Whew.
All
Thank
right.
you
That's
so
so
much.
much.
Dr. Booker has
Yeah,
a
one
hand
quick
raised.
question. I have one kid. So I was thinking of putting her on the deed of the house. We were thinking of adding her to the deed. Would it be better to add her to the deed so she inherits it, or go to a trust? Or put a house in a trust? And what
Okay.
about my jewels? Do I have to put all my jewelry into the trust?
Yes.
Or could she just pick it up from the house and go with it?
Give it to her for you pass away, or put it in a trust.
If I
All
put
right,
it in the
so,
trust and
but
she doesn't use it.
So the thing is this, ma'am, I think you should if you're in Maryland, do a family role planning session so that we'll know more about you and your interest and what you want. Do you understand? Because either way can work. But what is your goal? Do you understand? Is your goal to pass the assets to your child after you're gone? Or is your goal to pass the assets to your child while you are alive? So if you answer that question, that will tell you what you want to do.
While
Don't
I'm
worry.
alive.
I got your information to her as we speak. She'll be
Okay.
contacting you. She's in Maryland.
No, me, I'm in DC.
Sorry?
I'm in DC, sorry.
You're in DC? Why do I think you're in Maryland?
Yeah.
Schedule a 15 minutes call with me. Then I
Okay.
can answer your question.
Thank you. Thank you.
Fantastic.
So you're great. I love it.
I sent her information to you. So can you please give us your parting words in a few sentences? This has been awesome. Rich.
All right. Thank you all for holding on to this point. I hope it's been very impactful. So first of all, don't be afraid to have a plan in place. It does not mean you're going to pass away the next day. Secondly, if you love your family and you want them to get what you have with ease, then you need to plan. Because if you don't plan, the state has a plan for you, and the plan is not all that good. So if you're in Maryland, I would like you to schedule a family wealth planning session so that you have a one-to-one complimentary meeting with me, and use the code Medical Monday to get a $750 value for the meeting. It's usually a 2-hour meeting. So if you use that code and you schedule soon this February, you will get a free session. Oh, a $20 session. Okay, you'll pay to schedule your appointment. You'll pay to secure your appointment. But then it's going to be worthwhile because you'll be very financially organized to make sure your assets is not lost to the government. You will know everything specific to you and your loved ones. And then you'll be able to make informed decisions on how to protect your loved ones and assets from probate and unnecessarily mess in the event of incapacity or death. So I really appreciate the opportunity to speak with this audience tonight, and I hope you do something good for your family and loved ones. Thank you.
Thank you so very much. We appreciate you, and thank you for the gift you gave us on Medical Mondays. Medical Mondays family say thank you. I know them very well. Thank you. We appreciate you. And you will be getting calls from a number of us We appreciate you.
Dr. O, what about
Thank-
those of us that are not in Maryland? At least it can still talk to us.
So for those
Okay.
in Maryland, you can give me a 15 minutes call,
Hmm.
schedule a 15-minute call back, okay? If you want to get your estate plan done, we have a network of lawyers that do things the right way all over the country. I may be able to connect you with a personal family lawyer in your area to get your plans done. For the person in DC, still connect. For the person in any other state, still connect, okay? And we'll be able to guide you to get it done the right way.
Fantastic. Thank you so much. That is a sister. Do you all agree?
Yeah,
Thank you.
Yes, yes.
Thank you. And thank you,
Barrister.
Attorney Tinu,
Very
for
much.
connecting
Yes.
us. Thank you.
Yes, ma'am.
This has
Yes,
been
ma'am.
awesome.
We
Awesome.
love you. Yes.
Thank
love you
Thank
so
you,
much.
Sister Jumi.
I have
You're
posted
welcome.
and
Thank
reposted the contact information, and I will send it also by email tonight. So please contact her and learn what we need to do to secure our estates, whatever we have for our children. Please, we're seeing too many deaths with no plans. We shouldn't live that way. Thank you. Thank
Thank
you,
you very
everybody.
much.